Good morning. Please be seated. We have two cases for argument this morning, McNeilly versus State of Minnesota and Woolridge Carter versus State of Minnesota. We're going to call the McNeilly versus State of Minnesota matter first. Counsel, I'm going to give each of you 3 minutes to state your case, and then I'm going to give my colleagues an opportunity to ask you questions. Counsel, for appellant, I understand you have reserved 10 minutes for rebuttal? Yes. Very good. Counsel for appellant, if you're ready to proceed, the podium is yours. By the way, I should note that the Chief Justice is not participating in the arguments today or in the decision in these cases.
May it please the court, my name is Robert Richmond. I represent Kristi McNeilly, the appellant in this case. Ms. McNeilly was a practicing criminal defense attorney who was suspected of swindling one of her clients of $15,000. Based on that allegation from the former client, the police obtained and executed a search warrant for her home law office. They seized her computers and digital storage devices containing over 1,500 client files. Those files, the vast majority of which were irrelevant to the investigation and or privileged, remain in the custody of law enforcement to this day, 4 years after the search occurred. The law office search warrant and subsequent search warrant for the devices themselves were constitutionally unreasonable because they provided no procedure to protect against infringement of the attorney-client and work product privileges, and they were overbroad. In O'Connor versus Johnson, this court held that it is unreasonable for the police to rummage through attorneys' client files, even pursuant to a valid and particularized search warrant. Of course, O'Connor was limited to the case of an attorney who was not suspected of wrongdoing. But the concerns of the O'Connor court of the need to protect the sanctity of the privileges do not simply vanish when the attorney is the subject of the investigation. In particular, two principles which underscored that decision resonate in this case. First, documents protected by privilege are not subject to disclosure to the police, even if they are relevant to a criminal investigation. And second, even a particularized search warrant supported by probable cause for a law office is insufficient to protect the privileges and may be constitutionally unreasonable. Those concerns are at their apex when the target of the search is a criminal defense lawyer whose clients may be under investigation by the very agencies involved in the search. The searches in this case were unreasonable because the police took no steps to protect the privileges. First, the only process that was employed was a process to find those documents responsive to the search warrant and relevant to the investigation. To this day, no inquiry has been conducted to determine whether any of those documents, relevant documents, were also protected by privilege. They were simply all turned over to Detective Klingfuss.
Counsel, your time has expired, 3 minutes. Let me begin by asking you a question. It's my understanding from the record, and maybe I'm wrong about this, correct me if I am, that no privileged material was actually used in the prosecution of your client, and if that's true, does it matter? And if so, why?
Well, first, I don't think it's true. I think that I don't believe there was any privileged documents that were actually admitted as exhibits. But I think that the issue here is whether privileged documents were provided to the prosecution team, and that the answer clearly is yes. The privileged documents for both Mr. Wilson and Mr. Schumacher were provided to the prosecution team, and we don't know exactly what other documents were provided to the prosecution team. What we do know is that Meredith Peak, the forensic examiner, did a word search using terms like Piper for Detective Piper.
But I think the larger question here is the argument that the state makes is that there's no prejudice. And I'm wondering whether that argument has merit, and if so, or if not, why not?
Well, first of all, the cases that the state cites for that argument are cases that claim that violation, that infringement of the privilege impaired the Sixth Amendment right to counsel. They were not Fourth Amendment cases. And in some of those cases, this case in Anderson did not actually state a standard in those cases, but in those cases, some courts have said that in order to establish a infringement of the right to counsel, there has to be some way in which the right to counsel was impaired, and that was not shown in those cases. In this case, I think the O'Connor court, for example, has made very clear that the reasonableness of a search depends on procedures in place to ensure that the privileges are not violated.
Counsel, the privilege, oh, go ahead. Go ahead.
You sure? Okay. First of all, a couple questions. You're not making any Sixth Amendment claim here, right?
Correct.
Okay. And the attorney-client privilege belongs to the client, not the attorney, right?
Correct.
And acknowledging that attorneys may assert the attorney-client privilege on behalf of their clients, I'm wondering what, if any, legal authority supports the proposition that a violation of the client's privilege entitles the attorney to any relief?
Well, in this case, clearly Ms. McNeilly is aggrieved by this search. It was her front door that was broken in. It was her home that was invaded. It was her files that were taken. And it was her personal work product privilege, broader than the attorney-client privilege, that was violated by these searches. In addition, she has an ethical obligation to assert the privilege on behalf of her clients, which she attempted to do, going to court within a week of the search in this case in order to stop this unregulated rummaging of her client files, but was unsuccessful in this practice, in that process. And this court in O'Connor has stated, and I'm quoting, "In protecting these rights and privileges, we must take care to protect not only the rights of the client who is suspected of criminal wrongdoing in the case which prompts the search warrant, but also the rights of all clients of the attorney whose office is being searched." So while it's true, Your Honor, that the privilege, the attorney-client privilege, belongs to the client, in making the assessment under the Fourth Amendment and the Minnesota Constitution whether the search is reasonable, the court must evaluate the extent to which the privilege of all clients was violated.
Counsel, with regard to that issue, the state points out that the Doe interveners from the earlier appeal, the KM case, other clients, presumably of your client, are not part of this particular litigation as amici or interveners. Does that provide us with an indication that privileged information related to those other clients either wasn't found or isn't viewed as germane to this issue?
I don't think so, Your Honor. I was not involved in the KM litigation. Obviously, a strategic decision was made to solicit the involvement of those clients. I think as a practical matter, if the attorney does not have the attorney who is suspected of a crime does not have standing to assert the privilege on behalf of the clients, those interests are not going to be protected. I think it's, as a practical matter, it's unreasonable to expect that individual clients are going to intervene in a case such as this one, even have knowledge of a case such as this one in order to protect their own rights. And if anything, I would suggest the fact that the 4 John Does are not involved in this case is more a reflection of the fact that the damage is done. And there is nothing that can be gained from their perspective to prevent their files from being rummaged by the Dakota County Task Force or anyone else, because that has already happened.
Oh, you go ahead.
What do we do about the fact that both Wilson and Schumacher were the complainants in regards to what sort of started this investigation? Does that play into our analysis at all when you're talking about privilege?
I don't think there has ever been a valid waiver of the privilege with respect to Wilson and Schumacher. First of all, Schumacher was not the victim of the crime. He was not the complainant. He was a witness. I don't see any way in which cooperating with the police as a witness to an investigation somehow waives his attorney-client privilege. I think that would be a remarkable proposition. And even as to Wilson, there has never been an adjudication, which is a judicial determination of whether the crime fraud exception applies, whether he has waived the privilege. Those are determinations that should have been made by the district court.
Well, at trial, at the very beginning of trial, they did get a waiver, right, from Wilson before he testified?
I was not trial counsel. As I stand here, I don't recall that, but...
Well, I don't know if it matters because if there was a breach of the privilege, it would have happened before that waiver. But I'm just wondering what the implications of, I'll ask the state the same thing because it was done later. But what's the implications of, well, I guess maybe you don't have an answer, aren't familiar with that. Okay.
But I would also say that to the extent that there is a waiver of the privilege by Wilson, it would only be a waiver with respect to the circumstances surrounding this complaint, which was in the context of a drug case arising from a search at his home. He had an earlier housing court matter which related to drug dealing by his tenants from his home, which obviously in many ways could have implicated him. And yet we know that the housing court file, because it was responsive to the terms of the search warrant, were turned over to Detective Klingfuss. I don't see any way in which that he would have waived his attorney-client privilege as to that, or that any of the exceptions would apply to that. And so,
what is our? I mean, this is, I come from a civil background, and so typically, when privilege issues comes up, it's the lawyer for the person who has the documents who looks at the documents first, and then produces a privilege log, and then ultimately it's the court that decides it. But I mean, what does our law say about when can an opposing party make just an assumption that something is waived, or does that have to be done by a judge? Like, what if Wilson would have come in and said, "This is my file," and given it to the police, like he had a copy of his file?
Well, I think that would have constituted a waiver with respect to the contents of that.
Without a judicial determination?
I would say so. I would not take the position that the client cannot on his own. I mean, I guess maybe he should be advised by counsel before he does that. I mean, that's getting, I think, into issues that are not really presented by this case. But I think the client can certainly make a knowing waiver of the right to counsel.
And I'm just kind of trying to get to this question about what the line is when a judge has to become involved. Because typically, if it's contested, you'd want a neutral person to resolve whether there's even a waiver, because that's a legal determination.
Correct. And the problem here is that there was never a procedure whereby that process could be invoked. And so my position is...
So what about case law that we have, though, like, for instance, with retainer agreements, where we've said retainer agreements are not privileged? Can the police, like, even though no lawyer, I don't even know a lawyer ever looked at these documents, period, frankly, but can the police in a search say, okay, I know that the Supreme Court has said a retainer agreement is not covered by the privilege, and so I can take this?
I think that there has to be a process whereby the attorney under suspicion has an opportunity to review the documents and dispute claims of privilege.
And does that have to be the attorney under suspicion, or can it be that attorney's attorney?
So a representative of that attorney, either the attorney herself or a representative of that attorney.
Well, I can frankly see not wanting to turn over the documents to the actual
Sure.
client. But if the client has an attorney, if the attorney who's the suspect has an attorney, that seems a little bit different.
So, and there was never an opportunity for the court to be involved, and so everything was done at the behest of the police.
Do we know if there was ever an attorney involved in this to review these documents?
You mean from the state side?
Yeah.
Well, there was a Hennepin County attorney involved because Ms. McNeilly went to court to try to stop this process.
Before the stuff was turned over to Klinkva. So after the forensic investigator, who's not an attorney as I understand it, do we know if there was ever an attorney who actually looked at these documents before they were turned over to the prosecution team?
My understanding is there wasn't, that Ms. Peak made a determination of relevance, and all documents that were determined to be relevant were turned over to the police, the prosecution team, and there was never any process to say this subset of relevant documents, are any of them privileged?
And do we even know what documents Ms. Peak looked at? Has there ever been a list produced? I haven't found one in the record.
Well, what we have and I have included in the addendum, Ms. Peak's report, which indicates the search terms that she used and the number of hits, and their terms like informant had thousands of hits.
But we don't know what specific documents those
No.
are. Okay. And we don't know, do we know what documents Ms. Peak turned over to Detective Klinkvas?
Only in the most general way. We don't
have an inventory of the documents.
We don't have an inventory of the documents. We don't have a privilege log. There has never been a determination of privilege. It's our position that what should happen in a case like this is that there should be a highly particularized search warrant that in the search warrant itself makes clear that whatever documents and digital devices are seized are not to be reviewed by the police. They are to be returned to the court for safekeeping, at which point there is an adversarial hearing at which the attorney who was the subject of the search has a right to be heard, to assert claims of privilege, and then there has to be a process developed, which would depend on the circumstances, the volume of documents and so on, whether it be in camera review, a taint team, or a special master, to make a review for privilege. The attorney or her representative should have access to the documents that are deemed to be non-privileged so that she can assert privilege claims, and those claims should be resolved by the district court, and only then should documents be turned over to the prosecution team.
Counsel, can I stop you on that? You're laying out a very, very detailed process. And I'm wondering how that comports with what we said in our Poole decision, because Poole sort of lays out a range of things that could happen. Some detailed like you're talking about. I mean, I think it even mentions the possibility of in-camera review, but it also has, you know, a much more general list. And I'm wondering if that is not a framework to the extent we want to articulate a new process going forward, since we've really not spoken to this issue. I wonder if pool isn't a better framework, just because it, you know, it lays out a range of things, you know, from more general to very specific like you're talking about.
My view is that in the context of a law office search, there needs to be more teeth than pool provided. And I am very cognizant of the fact that there is no one procedure constitutionally mandated, but the only part that I would say should be required is the adversarial proceeding. At that point, that is when the totality of the circumstances can be contemplated in determining whether we
would
want a
have,
special.
you're asking for a special rule when it comes to law office searches.
Yes, Your Honor. And I think that's appropriate under the framework of
And should that be
O'Connor.
prospective or retrospective? Because there's not been anything like that required.
Well, Your Honor, I think that what has always been required is that a search be reasonable. And I think this search was unreasonable. The issue here is not should it have been a special master or should it have been a taint team. The issue here is should there have been something. And after O'Connor, I think it's appropriate that the rule be retrospective, because where the police did absolutely nothing, as far as we know, did not involve a prosecutor or counsel to make any determinations as to privilege, it is appropriate that the remedy here be suppression.
Counsel, is it accurate to say that they did absolutely nothing when they tried to sort out all of the things that, all of the client's documents that didn't pertain to the two at issue here?
It's our position that a review for relevance does nothing to protect the privilege.
For all clients, or the, you know, for Mr. Wilson and Mr. Schumacher?
Both. I think that with respect to other clients, I mean, obviously search terms for Wilson will pull up all files relating to someone named Wilson. A search for Piper will pull up all contacts with Detective Piper. We don't know on this record which of those for other clients were turned over to the police, but I mean, I agree that what was turned over to the police was a subset of the huge mountain of documents that existed in the search warrant, or that existed in the computers, but as to those, nothing was done to determine whether that subset was also privileged. And I should also say that the search warrant in this case did not require this procedure. By the terms of the search warrant, Detective Klingfuss was free to print out every email, every letter, every document from those computers, and then personally scan every single document to determine whether it mentioned Wilson or Schumacher.
Can I just turn, because we're getting down to the time, to the remedy question? So assume that we agree with you that there was a privilege problem and which rendered the search unreasonable. Okay, then suppression is the typical remedy under our case. But is that decision subject? I mean, there's this discussion about prejudice. I'm not sure if it's an argument. Is there a harmless error analysis we do? Like, even though there's if there's a constitutional violation with evidence, sometimes the question becomes, well, is it harmless beyond a reasonable doubt, right? Does that apply in a Fourth Amendment suppression context? There's very little case law that I've found on this.
Well, I think the harmless error question would be whether whether the results of the search affected the trial. And here it clearly...
So you're, just to clarify, so you're saying that we can do a harmless error analysis and then go on and explain why it's not harmless.
But it's not harmless with respect to attorney-client privilege. It's harmless with respect to the search. And here, most of the exhibits came from the search, the retainer agreements, the QuickBook entries. I'm not saying those were all privileged, but they were all the product of the search. In Groh versus Ramirez, the Supreme Court case, the issue was whether an overbroad warrant can be saved by the police doing a reasonable search, and the Supreme Court said no. The warrant was overbroad.
But what about
what
if we don't go under overbreadth or particularity, but we make a decision under unreasonableness?
I'm sorry.
If we're not talking about that the warrant itself was overbroad, what if we say the search was unreasonable because you didn't do anything to protect for the privilege? Is that subject to harmless error and unreasonableness of a search?
I think that
if a search is unreasonable, typically you get rid of the entire search, right? I get that point. But can we say we don't have to get rid of the entire search because even if the search was unreasonable, it wouldn't have, any document that came from that search wouldn't have affected the outcome of the trial?
Counsel, your time has expired, but please go ahead and answer that question.
I think that the law is, in the Fourth Amendment context, that if the search was unreasonable and or the warrant was overbroad, which I am asserting both in this case,
right,
that the remedy is suppression. And so, I mean, it would, the harmless error analysis would be if the product of the search did not come into the trial at all, but it did. And so
okay, that's your
the error here was not harmless.
Okay, thank you.
Thank you.
Counsel, you have 10 minutes for rebuttal. Counsel for respondent?
Good morning. May it please the court, counsel. I am Assistant Hennepin County Attorney Adam Petrus, and I represent the respondent, the state of Minnesota. No Minnesota law requires specific procedures like a special master or a filter team unaffiliated with law enforcement. This court should announce a prospective rule with safeguards for situations where an attorney is the target of a criminal investigation. That rule of law should be grounded in the touchstone of the Fourth Amendment, which is reasonableness, as determined on a case-by-case basis. This court can provide safeguards for investigators, for prosecutors, for trial judges to consider that will both protect the attorney-client privilege and also recognize the fact that attorneys cannot use that privilege to shield their own illegal conduct. And in announcing a prospective rule, this court should affirm in this case because the investigation here was reasonable. Now, it's very easy to get lost in the weeds on this case, but at its core is the simple and basic principle of reasonableness based on the totality of the circumstances depending on the case that presently exists. I believe, as Justice Hudson mentioned before, that the precedent that is most helpful to this court is Poole. And to be clear, the state is not saying that the facts in Poole are strikingly similar to what happened in this case. Rather, that part of the point is that there is no precedential decision or authority in Minnesota that is strikingly similar. And in Poole, this court provided safeguards that could apply in a case-specific analysis, depending on the nature of the activity under investigation. And those guidelines included having a centralized review, first using less intrusive investigation techniques like the subpoena process, having judges carefully review detailed warrant applications before authorizing searches, and all of those things happened here in appellant's case. Now, law enforcement recognized that the attorney-client privilege issues that were present with appellant's non-victim clients, and they went to lengths to ensure that those privileges would not be violated. And at each step, law enforcement took precautions to protect those privileges while still investigating a crime that undermines the very systems that appellant, as a licensed attorney, had sworn to uphold. The precautions that the law enforcement employed here were eminently reasonable, and that is exactly what present controlling Fourth Amendment legal authority for this particular type of situation requires. This court should announce non-binding safeguards going forward that allow for a level of flexibility in considering the totality of the circumstances of a given situation. But this court should also hold that law enforcement's careful approach in this particular case was reasonable under the Fourth Amendment. I welcome this court's questions.
Counsel, let me start with page 12 of the reply brief here, and I'm just wondering if the state now concedes that it has abandoned the claim asserted at the Court of Appeals that Peak acted as a filter or taint team with respect to the privileged material. Do you agree that there was no filter or taint team dealing with the privileged material?
I don't agree. I stand by that. I stand by that argument, and I believe that was incorporated into the Court of Appeals holding in this case as well, that Ms. Peak acted as a filter team.
But doesn't a filter or taint team look at privilege? You're not asserting that she actually had any, like, even training to look at the privilege, right?
I don't believe there's anything in the record that
She's not a
supports-
lawyer, right?
She is not a
So
lawyer.
no privilege review is, I mean, typically a taint team is, like in the last case we had, they were actually looking for privileged documents. I mean, it's the phone conversations.
Yep.
There was no privilege taint team in this case at all.
When you say the last course that you had, are you referring to something cited in the brief, sir?
That doesn't matter.
I
So,
apologize.
Yeah, it was, so.
We've had portions of this argument before.
Yeah. So, but there was no privilege taint team here at all. No review was done for privilege in this case.
If we're going to characterize a filter team, if we're going to define it legally as having to do with privilege as opposed to filtering other things, then yes, Ms. Peak did not, I believe.
Did any
training
lawyer
to look at privilege? I think effectively what she did, though, was, I mean, besides screening for like relevancy to both Mark Wilson and Jason Schumacher, she effectively screened for privilege, because some of these court's questions this morning went to who actually has the privilege. And obviously, Mr. Wilson and Mr. Schumacher had that privilege. And going to one of your other questions, Justice Thiessen, from before, I mean, this court has repeatedly held, Whalen is a good example, 2010 Supreme Court, that an implicit waiver of the attorney-client privilege can happen when the client alleges some sort of breach of trust with the client. Alleging that an attorney swindled you out of $15,000 is an example of one of those
in Wayland, did a court look at that? In Wayland, did a court look at that?
In that context, I believe it was an ineffective assistance claim. So yes, there was. I don't know if there was a specific waiver that was done on the record. I'm not familiar with the record in Wayland. But to go to your question earlier about the record in this case, I was also not trial counsel. I was also not a previous appellate attorney. I did not write the brief. So I tried to access the transcript because my recollection in scanning it quickly was there was such a waiver done with Mr. Wilson.
There certainly was at the trial or at the suppression hearing. That is.
I believe it was at the trial. I do not believe Mr. Wilson testified at the suppression hearing in June 2020. But I could not pull up the exact transcript site for you this morning. Okay.
Counsel, the great white whale in this case is the privilege issue, and I understand your argument about controlling precedent and all of that, but I'm looking at the seizure of hundreds, thousands of pages of confidential records that belong to other clients, and there's no privilege analysis at all conducted by the state here. I mean, I look at this from a Fourth Amendment perspective, and why aren't we in automatic suppression territory and new trial and we all go home? No doubt I'm greatly oversimplifying things, and you can explain why I'm wrong, but that's my concern. This is what I see here.
This case is not O'Connor, and I believe that would be the only legal authority that could be pointed to as an automatic type of suppression situation. So going to the last part of your question, Justice Anderson, is that I don't believe there's any legal authority that compels the result that you're concerned that you may have to reach. And what was done by Ms. Peak was identify just the documents, and someone who was walled off from law enforcement. Yes, Ms. Peak works for the Dakota County Sheriff's Office as part of that task force, but she was not involved in the investigation in this case whatsoever. That is why I responded yes when I said we're maintaining our position that she acted as a filter team, perhaps focusing more on relevancy than as opposed to legal training in what constitutes privilege. But the privilege that she was, when I said effectively scanning for privilege, I mean, you had the waiver of the attorney-client privilege by Jason Schumacher and by Mark Wilson. And so by looking for documents that involved just them, anything that was identified as being involved in their case, which they had already spoken to law enforcement about, Mr. Wilson had actually spoken to other attorneys about as well, the record supports that. That's what I mean by that implicit waiver of the attorney-client privilege.
And counsel, in fact, they had requested their files, if I'm recalling correctly, from Ms. McNeilly, and she did not turn those over. And also, their subsequent attorney had requested their files.
That is true. Mr. Pauly, as well as Mr. Wilson, had made those requests, and they were rejected by appellant in this case.
Counsel, I think I understand what you're saying about the waiver of the attorney-client privilege, but how about the point your opponent makes about the work product privilege here? Is there any authority that there's an implicit waiver of the attorney's right to keep work product safe from the government in a circumstance like this? I mean, doesn't that belong to the attorney as opposed to the client?
I agree it does, and it's different. I don't believe there's support for an implicit waiver of the work product privilege as distinct from the attorney-client privilege in this case. I think to analyze it under the work product realm, we need to look at the documents that were actually received here. And I want to be very clear. There is no Rule 9 allegation against the state. And why I say that is because everything that the prosecution ultimately received from Ms. Peak that were on appellant's computers, that was turned over to appellant. I mean, it was everything that's in the prosecution's possession, obviously, has to go to the defense. So every single document that was pulled off those computers, the defense has. There's not a question about what it was. Some of them were featured at trial, Exhibits 13, Exhibit 16, which are the confidential informant forms. And going back to your question, Justice Moore, I mean, the work product privilege, as I understand it, protects things that are prepared in anticipation of litigation, showing like the theory behind, you know, when you're preparing a case for trial, preparing for litigation. None of the information that was received from Ms. Peak, which again, both the state and appellant have, comes anywhere close to constituting work product. So from a prejudice perspective, if the court needs to reach that in deciding this case, there is no violation of the work product privilege based on the information that was actually received from this multi-step process involving the Dakota County
Counsel,
Sheriff's
though,
Office.
you know, one thing that troubled me a little bit, and I hadn't thought about it this way until your opponent was responding to Justice Thiessen about the harmless error analysis. And what I heard him say, or at least what I understood him to say, is that we need to look, if we get to that point, we need to look at it from whether or not the information that came in as a result of the search was harmless or prejudicial, and not so much the privilege information, because it sounds like none of the privilege privilege documents actually came in, and thus there is no prejudice there. But I think your opponent's point is there were other documents that came in, like the confidential informant forms, which were vital to the state's case. I mean, those were key. And so that's where the harm comes in. So I'm hoping you can address that sort of dichotomy, or if that, in your mind, is the way we ought to be looking at harmlessness if we get to that point. I don't know, does that make sense?
It does.
Okay.
I want to push back on one part of your question, which is I don't believe they were absolutely vital. I mean, there was a fair amount of evidence coming from Mr. Wilson's testimony, the phone records, the bank records that were
But that was one of the key terms, though, that Ms. Peak was looking for in terms of the relevance, because of the deal that was allegedly struck with Mr. Wilson, that, you know, you can either become a confidential informant or not, and so...
Right. It really comes down to the forms. I mean, there were sales invoices as well that came from the search as well, but it comes down to Exhibit 13 and Exhibit 16. I'm not aware of anything else that really made it into the record that was vital, or I wouldn't even say that was vital, but was, I mean, strongly supportive of the state's theory in this case. I'm not aware of any legal authority, to go back to your general question, Justice Hudson, that supports you have to suppress everything that came from the search, even if the basis for that challenge is a privilege violation.
I guess that's what I'm getting at, because it seems like we're talking privilege, but he's talking something broader than privilege.
And if
'cause
this
none of the
court-
privilege stuff came in.
If this court would like to make a rule like that I am not aware that exists anywhere else. I don't believe this court has said that before. It is welcome to. The state does not think that is the best rule, but this court would be welcome to do that. However,
Why is it not the best rule?
What?
Why is it not the best rule?
Because it's not at all related to the violation. I mean, the violation, the basis for the violation would be a privilege violation. And if the contents of that search did not actually violate that claim for why the search was wrong, it would seem to be a great overreach, to be honest, in terms of a remedy.
Well, except that and we'll hear more about this tomorrow too, but one of the arguments about the unreasonableness of the reason we have the exclusionary rule is to deter, I don't know if you'd call it misconduct here, but to deter the police from doing overbroad searches. So that's kind of the whole point of the fruit of the poisonous tree too, right? That if you have an unreasonable search, my understanding has kind of always been that the search goes.
And the point I was driving up, I was getting way too long-winded about it when responding to Justice Hudson, was what Justice McKeag said before, is that a prospective rule as opposed to retrospective here. I mean, you did not have any legal authority on point back
Well, we don't
in
have to
spring.
get to the prospective rule if in fact we could just say that to get to the prospective rule, we have to decide this issue. That's more what I'm.
I understand.
But if you're okay with just getting saying that if you're okay with the rule that says if it's only an objection as to privilege, you don't have to suppress anything that's not privileged. But we would say you would have to suppress that even if it's not privileged. If that's okay rule, then we do get to whether it should be prospective or retrospective.
I agree. And I want to be clear. I want this court to announce some sort of rule. I tried to be clear about that. My former colleague who wrote the brief, I think, was clear about that in the state's brief to this court. And I don't think it should be the rule that you're describing, Justice Thiessen. That seems to be more along the lines of what happened in Poole in terms of safeguards that apply to it, the totality of each individual circumstance.
And would that include having to do a privilege review
It may.
by a lawyer?
It very well could. That's something that should be considered.
Well, what is the state's position on that?
I would caution you from requiring it in every single case. I think that.
What about for law? So I'm talking, it would probably be a special rule. If we do a special rule for law firms, do you think that an independent review for privilege, or at least a lawyer reviewing it for privilege, is something that we should include in the rule?
If this court does that, I will try to answer your question directly, I know. But if this court were to do that, I mean, there would be a lot of other, practical realities to consider in terms of, a search warrant, is presented to a magistrate. And it is approved to obtain, a computer, not to search it, but to obtain a computer or any physical file that may be in that law firm's or that attorney's office. Then what would be the process for finding an attorney to do a privilege review at that point, which based on our colloquy here, I think you think that the privilege review should be conducted by an attorney in place of what Ms. Peak did in this case, where she was searching for relevancy.
Or in addition to.
Or in addition to. And, okay, because, practically speaking, and I want to really ground this court as it's providing guidance to lower courts and practitioners into the practical realities, you're going to have electronic files. That's what I believe the detective anticipated in this case, which is why he put in that first affidavit, we're not going to be doing any searching. That's going to be a separate warrant and a separate process. So if you were to, obtain the tower computer, obtain the thumb drive, you would need a forensic specialist to extract some information that is on those devices before they could be presented for a lawyer, unless you'd want either you or I, and I know I wouldn't want me, combing through someone else's computer to try to figure out where the information is. And
Counsel, I want to go back to the reasonableness issue, and your opponent on page 27 of his brief notes that everybody was on notice that we had a problem here early on because McNeilly was in court within 72 hours talking about privilege issues. And I believe he asserts, I don't know if this is true or not, that the search had not yet commenced. But in any event, at that point, The state knows it's got a privilege problem, and yet it did nothing about it. Does that deal with, by nothing about it, I don't mean to be critical in the sense that a criticism of Ms. Peak, but she's not a lawyer. There's no attempt to address the privilege issues. Does that affect the reasonableness analysis here?
It can be taken into account, but it is not dispositive. It does not make what happened in this case unreasonable.
Why not?
Because generally speaking, I mean, when law enforcement were to see something, they would be able to look in any container that, could possibly,
An allegation now of a privilege problem. I mean, again, sort of in the abstract, you seize the stuff, nobody says anything, you've got this procedure set up. Okay, maybe it's reasonable, maybe it's unreasonable. Now you've got an actual assertion by, at least at the time, a licensed lawyer saying there are privileged documents that are of concern here, and the state doesn't really deal with the privilege issue. So doesn't that make the search unreasonable? And if not, why not?
Justice Anderson, I was not involved in the KM litigation. You presided over that case. You may know this record better than I do, but as I recall in KM, the issue was about the return of the physical computers and devices to appellant at that time, brought under Minnesota Statute 626.04. I do not believe attorney-client privilege was an overriding, argument in that case. And then obviously, like Justice Moore pointed out earlier, the people who may have had a privilege that was not constructively or implicitly waived in that case, the John Does, did intervene themselves and were a party and did argue before this court. And that did not happen here. I think, so that all goes into the reasonable analysis.
But counsel, if I could maybe add on to Justice Anderson's question, privilege is the key issue here. And what I understand your opponent's main argument to be, Mr. Richmond's main argument to be, is that a relevance analysis or a relevance, overlay, which is what Ms. Peak did, doesn't suffice for, doesn't in any way address privilege. And I'm still looking for the state's best answer to that, because I think it's just a version maybe of Justice Anderson's question.
I believe because Mark Wilson and Jason Schumacher had implicitly waived their attorney-client privilege, requested their files back, were not at all trying to conceal any of their communications with appellant, that by searching for the information in appellant's possession that pertained to Jason Schumacher and Mark Wilson, there was going to be no violation of the attorney-client privilege with respect to those two individuals. In terms of all of the other unnamed non-victim clients whose information was contained on appellant's storage devices, electronic devices, thumb drives, I would point this court to Anderson, which was cited in the brief. And there was indisputably a violation of attorney-client privilege when there was listening into, and this is what I thought you were referring to before, Justice Thiessen, phone calls that happened between the defendant in that case and his counsel. But there, as soon as it was determined, as soon as, a few words were listened to, that this was not, relevant, this was not in that particular case, it wasn't relevancy, but oh my gosh, this was a privileged conversation, the listening stopped, the access stopped. And that is what Ms. Peak did in this case. And that level of insulation that she provided by being walled off from the investigation, not involved at all with the later prosecution.
Well, except that there it was lawyers who were, there was lawyers listening in, right? And so they actually had the training to make a privilege determination. I mean, that is, I don't know if that's a dispositive difference, but that is a difference from Anderson.
I acknowledge there's a difference between what Ms. Peak's legal training is and what
and you're not,
presumably
and
the
you're not,
lawyers
and the
in Anderson's
state's
legal
position
training
is not that Ms. Peak can do a privilege determination. I mean, except for she's screwing out relevant documents. I get that argument, but just to make the legal decision as to whether a particular document is privileged, she can't do that.
Effectively, I think law enforcement was having her do what they construed as a privilege determination. I'm not sure if there's anywhere in this court's case law that specifically defines a privilege check in the context that we're talking about here today.
Well, but I don't know that we'd allow a paralegal to do a privilege. You can do a review, but an attorney has to look at that.
If that is the requirement for a privilege review to happen, that needs to be an
So
attorney,
the
it
state's
did not
position is
happen in this
that,
case.
the state's position is you don't need an attorney to do a privilege review?
The state's position is that the law is not clear about whether you need it or not, and that is the point here.
Can I ask you a question about the warrant? Of
course.
And the particular, thank you. Particularity. So in the first warrant, I don't think there's any disputed authorized seizure of the computer. And it also said you can, and then it specified certain things you could take physically, like the files and confidential informant forms. So it did lay those out. Do those limitations, well, what would you think of a rule that said those limitations on the premises search are also limitations for a computer that's seized as part of the search? So that when the police go in and they have a premises search that says you can get these specific kind of documents, and then you can seize a computer, you can't look, that warrant is telling you can't look at anything on that computer that is not listed in the premises warrant. Does that make sense?
To ensure that I understand your question correctly, if I'm hearing you right, under that particular view, the second warrant would really not be necessary because that first warrant would cover exactly what ultimately happened in this case when they were just, when Ms. Peak was searching the computers themselves for those specific items that were listed.
Yes, the search of the computer is bound, limited by the items listed otherwise in the warrant.
Yeah, I believe that is what was accomplished by the second warrant, but under that interpretation, then the first warrant would be sufficient in itself, which ultimately goes to the reasonableness of what the police did in this case.
I mean, I don't know that we've ever said that, and I don't know how people view warrants. It might be a change in law. I just want to kind of get a sense of what the state's position on that would be. If that is, I mean, if that's the rule we announce, that's going to affect every other warrant too.
No, that rule makes sense, and it especially makes sense in the context of this particular case, because what they were looking for is those individual items at the end, like the last 5 items. I think they're specifically listed in that first warrant. You know, confidential informant forms, any files, invoices, or documents associated with the representation of Mark Wilson or Jason Schumacher. Those were, I mean, the state's position is those were tangible things, so like paper copies that were going to be found in that office. But it would be very consistent with, if you can find a paper copy, a digitized version of that, but just of that as opposed to the digitized version of everything else that may be saved on a computer.
Counsel, regarding the reasonableness issue, district court judge made a number of findings regarding this search, and I think the ultimate conclusion she reached was that the actions here were taken with, I think, a considerable amount of care or some language to that notion.
Significant amount.
Right, and there were fact finding regarding what actually did occur with regard to the officer's conduct. Is any of that material in our analysis? I mean, do we give any deference to that? Is this totally a de novo review situation where we are reviewing everything independently, or do we get to give any deference to what the district court saw during the evidentiary hearing?
Justice Anderson, I'm out of time. May I take some time to respond to Justice Moore's
Not only can you respond to that question, Justice Thiessen also has a question for you. So and I guess Justice Chudy, so you're not done yet. Go ahead and answer, Justice Moore.
Duly noted. I believe the standard of review is the same as should be applied in any situation involving a search warrant, which is the factual findings on those first 4 pages of Judge Conroy's order should be reviewed for clear error. And those were the factual findings that you were just referencing, Justice Moore. And then the legal ruling should be treated with de novo review. But that is the standard review that should come in here. And specifically the factual finding that the steps taken, by Ms. Peak demonstrate a conscious effort to avoid a general exploratory search prohibited by a Fourth Amendment. I believe that's one of those factual findings as well. That should be reviewed under clear error given the totality of the record.
Thank you. I just want to get a sense on the prospective rule. So in the brief, which is not I know you didn't write, but there's a reference to Lindquist, but there's never like an explicit statement, we want the good faith exception to apply here. So what's the theory for prospective relief here? Because if it's an expansion of the good faith exception to say the good faith exception applies when there's never been any law one way or the other on something seems, I mean, personally seems very scary to me. It would swallow the rule, right? I mean, in some sense, except where it would be like qualified immunity. The U.S. Supreme Court's law on qualified immunity. So is it a good faith exception, or is there some other, what's the legal rationale for doing it prospectively as opposed to retrospectively here? Setting aside, that you don't think it was unreasonable, all that stuff.
That will be part of my answer to the second half. But going back to the Lindquist reference, I think that was the problem with a clear application of Lindquist, because there was not a specific on-point rule in a precedential authority from this court or the Court of Appeals to apply to this particular decision. So, I mean, I totally understand where you're coming from, Justice Thiessen, in that there was a dearth. It was just, there was not any binding legal authority about what law enforcement should have done necessarily in this case, where you're dealing with the target of an investigation, which is why, as this court has already distinguished, O'Connor does not apply to the facts that we have here. So I think I think the reference to Lindquist was more that, I mean, if we are looking at what was binding, at the time, back in the spring of 2019, all that applied would have been a pronouncement or a principle similar to what this court said in Malno, which is that, was it reasonable? And so that is.
But that's ultimately that's ultimately the question. It just seems like we can't have a rule that says anytime we've not defined something as unreasonable, the rule only applies prospectively.
I don't believe the brief said that, and I'm not saying
that's why I'm asking what's the position.
I think that for the same problems that you just identified in your question is the reason that probably doesn't make sense long-term in terms of announcing a concrete rule, but it was just, I think, cited to illustrate the point that when there is not on-point authority, like directing the opposite, and law enforcement, for better or worse, was operating a bit of a vacuum in this particular factual situation, I mean, there's perhaps some conceptually, as opposed to legally binding, but conceptual deference paid to law enforcement's, actions and whether or not they were reasonable.
Justice Chudich.
This is sort of aside from what we've been arguing about, but the amici say that the state still has the files of clients the irrelevant files. And I'm hoping that the state is taking precautions with those files.
Speaking from lots of practice experience, I know law enforcement almost always wants to return things that are gathered as quickly as they are gathered from very practical storage reasons. And I think in this particular case, that will be returned in this particular situation to appellant as soon as we reach a final judgment here. But the general advice to all law enforcement agencies from every prosecutor I've ever spoken with is that the information needs to be, anything that's gathered in a case needs to be maintained until there is a final judgment that's issued. And I understand with the post-conviction statute that nothing perhaps is ever untouchable. But getting to your question, Justice Chudich, I think that is why that the computers themselves, electronic devices themselves, are still with, I won't believe they're with Dakota County. I believe they are physically, because they were just working with an image of the files. I think they're back with the Burnsville Police Department.
Counsel, your time has expired. Rebuttal.
Thank you, Your Honor. I want to circle back to where I began with O'Connor. It is unreasonable in any case to permit law enforcement officers to peruse miscellaneous documents in an attorney's office while attempting to locate documents listed in a search warrant. Granted, that case involved an attorney who was not suspected of a crime, and we are not suggesting here that law offices in the circumstances of this case are immune from a search warrant or that a subpoena was required instead. But the principles underlying O'Connor for law office searches apply here. The idea that Ms. Peek acted as a filter team, as she testified, her only function was to look for documents that were relevant to this case. And granted, that reduced the size of the documents that were available to the police, but it did not deal with the issue of privilege, an issue that the police were on notice of within days of the search when Ms. McNeilly and her attorneys went into court in the KM litigation. And while it's true they
Counsel,
were seeking the return of property, they were seeking the return of property based on O'Connor.
Counsel, if we disagree with you as it relates to privilege of Schumacher and Wilson, do you lose?
I'm sorry?
If we disagree with you and we find that there was a waiver, whether implicit or otherwise, of the privilege related to Schumacher and Wilson, do you lose?
No, Your Honor, because I think there needed to be, the search here was unreasonable under the principles of O'Connor. And the issue now is not retrospectively, looking back whether there was a waiver, but whether there was a procedure for determining claims of privilege and claims of waiver at the time, before this search was conducted. I think your question goes back to the issue that the state has posited, which is that even if the search was unreasonable, we just look to see whether attorney-client privilege documents were introduced into evidence, and if not, there's no prejudice. That's not the way the Fourth Amendment works. That would be gutting the Fourth Amendment. The issue here is, was the search—
And what authority would you cite for that?
Well, I would cite Groh versus Ramirez, where the state said, our search was reasonable under this overbroad warrant, and the Supreme Court said that doesn't matter. You don't look at an overbroad warrant and say, but the exhibits that were introduced were within the core part of the warrant, the part that was supported by probable cause, so there's no prejudice. The prejudice is that the search was unconstitutional and the fruits of that search were introduced into evidence. The exact same thing is true here. The analysis, the appropriate—
Counsel, does it matter that it's because of privilege here? Like, I'm trying to think, say we agree with you, can we then look under like a constitutional harmless error analysis and just exclude all the documents and say, can we uphold this conviction of guilty without looking at any of the documents that came in?
I think that sort, I mean, if the documents were just, I think probably that sort of harmless error analysis would be appropriate, Your Honor. I concede that, but I think, as the court mentioned, I think, for example, the confidential informant document was devastating to the defense. I think that was probably the most significant piece of evidence in the case. I think it was vital. So while I agree that as a technical matter, if the only documents from the search, say, were envelopes showing that Ms. McNeilly lived at that address, there would be harmless error in that situation. I don't think that's our situation, Your Honor. And again, with respect to—
Counsel, remind me, did Mr. Wilson testify?
Mr. Wilson testified
I thought
at
so.
trial.
And so when you look at the strength of the other evidence, apart from the confidential informant forms, Mr. Wilson testified. I mean, that seems to me to be very, very strong evidence.
Without the search, there would be essentially no corroboration of Mr. Wilson's testimony. And he is claiming that, essentially, that he agreed to a bribery scheme, not realizing that it was actually a fraud scheme.
But you also have the evidence, I forget who did the officer that did the investigation, that never saw any conversations between Ms. McNeilly and that the other police officer, which of course, that was part of the whole, allegedly, the whole story, which is, I've got this deal with Officer Piper, was it maybe, or whoever it was, you know who I'm talking about. I've got this deal, but when they looked at the phone records of both the officer and Miss McNeilly, there was no evidence of any of those conversations during the time frame in question.
Correct, but the defense was not that this was actually a bribery scheme, not a fraud scheme. The defense was that there was no scheme at all and that Mr. Wilson was trying to get out from paying his bills. And so under the fact that there was no call to Detective Piper was completely consistent with the defense.
And the fact that then it appears that the lawyer, contemporaneously took a Texas confidential informant form and altered it is pretty damning evidence.
Very damning evidence. I think it was I think that was the smoking gun.
Justice McKeag asked a question, which I hadn't thought about, which is, what is the effect that that Wilson and Schumacher, this is going to the waiver question, asked for the files and your client didn't turn them back over to her? What do we do with that information?
I think that the record from the suppression hearing and possibly from the trial as well indicates that those requests were sent to the wrong address, so it's not clear that Ms. McNeilly ever actually received that request. But I don't think that simply requesting your file establishes waiver. I mean, sending your file to the police may establish waiver, but simply requesting your file does not establish a waiver. I don't think that point really is significant in the context of this case.
Counsel, what about his conversations with the other attorney that he sought advice from? Was that a waiver of his attorney-client privilege with Ms. McNeilly? Mr. Pauley or Paul or?
Pauley.
Pauley.
Again, I don't think that would constitute waiver with respect to the contents of his file or a waiver vis-a-vis the police. I think that until the investigation was done, I would say that, I mean, not that there was a joint defense agreement, but that he had more than one attorney at the time, and I don't think it's a waiver to tell.
Well, counsel, what would be a waiver? You've got a gentleman who he's telling everybody under the sun about this allegation. I mean, he's telling another attorney, he's telling the officers, he testifies at trial. I mean, what would it take to waive it if not that?
I think it would take a colloquy with Mr. Wilson saying, do you waive
So an out-and-out explicit waiver.
Yes, Your Honor. And certainly with respect to the housing court matter, which had nothing to do with this. I don't think that most people filing a complaint against an attorney are of the understanding that everything in their file, all of their darkest secrets that they told to their attorney is now going to be public information by virtue of that complaint. But
So is it your position, counsel, that Ms. McNeilly was still Mr. Wilson's attorney? Because there was the email exchange where essentially she says, good luck, when he was asking for the refund, for the invoices, for his file, and she essentially says, go on your way and good luck to you, and then ends the conversation.
Yeah, I think I agree that at some point the relationship was severed, Your Honor. But I don't think that that affects the issue of waiver. If there's nothing further, I see that my time has expired. We would ask the court to suppress. Thank you, Your Honor.
Thank you, counsel. We thank both counsel for your participation and assistance in this matter today, and it is submitted and will be decided in the ordinary course. We'll call the second matter before the court today, Woolridge Carter.